for hearing Business Application number 4 of 2021, arising from Presidential Election Petition number 1 of 2021, Kyagulanyi Sentamu Robert, the applicant, versus Yoweri Museveni Tubihaburwa Kaguta, the Electoral Commission, the Attorney General for the respondents, before the Honorable Mr. Justice Alphonse Kyagulanyi Owiny-Dollo, the Chief Justice.
The name is not Kyagulanyi. I don't know that fellow. Look up the,
my lord.
yes, look up the letters. There's no A. Would you like to say it again?
Kyagulanyi
Right.
Owiny-Dollo, the Chief Justice.
Yes.
Honorable Lady Justice Dr. Esther Chitimbo Chisache. Honorable Lady Justice Stella Racha Amoko. Honorable Mr. Justice Ruby Opio Aweri. Honorable Lady Justice Faith S. Mwanda. Honorable Mr. Justice Paulo Kaivale Mugamba. Honorable Mr. Justice Ezekiel Muhanguzi. Honorable Lady Justice Pasenai Tuhaise. Honorable Mr. Justice Michael Chibita.
May it please you, my lord, the Honorable the Chief Justice of the Republic of Uganda, and my lords, the Justices of the Supreme Court. My names are William Biaruhanga, the Attorney General of the Republic of Uganda, and I'm appearing this morning with Mr. Francis Atoke, the Solicitor General of Uganda, and we are both being assisted by Mr. George Kalemera, Commissioner, Civil Litigation, for the third respondent, my lords. My lords, the first respondent is represented by Mr. Chiriowa Kiwanuka, Mr. Edwin Karujire, Mr. Ebert Biencha, together with Mr. Ebert Biencha. My lords, the second respondent is being represented by Mr. Joseph Masiko, Mr. Ellison Karuhanga, Mr. John Jet Tumwebaze, Mr. Alfred Oriem Okello, and Mr. Eric Sabiti. For the parties, my lord, the Electoral Commission is also represented by the Honorable Stephen Tashovia, who is a commissioner with the second respondent. My lords, counsel for the applicant are represented by the Honorable Medad Lubega Segona, Mr. Samuel Muizi, Mr. Solomon Kakeire,
Sulaiman, my lord. Sulaiman for the record.
I beg your pardon, Mr. Sulaiman Kakeire, Mr. Sekanjako Abubakar, Honorable Chiwanuka Abdallah, Mr. Sekaja Ukasha, and Mr. Frederick Karule.
Sekaja Ukasha, my lord. And Ukasha, my lord, is UKASHA. Frederick Karule, my lord.
And my lords, we are ready to proceed. However, with your permission, my lords, as head of the bar, I would request your permission, my lord, to address the court on a matter that I think concerns the conduct of this trial, my lord. My lords, are more than slightly concerned about the current emerging trend of this trial. And here are my reasons. This court went to some length when we were last here attending to the application for amendment, I think just last week. This court went to some length to guide the parties on the way going forward. Indeed, I recall that the court made mention of a choice of placement of parties' grievances. The court did say that when a party has grievances or a grievance, they have a choice of where they want to go. In this case, the parties chose to come to this court. But what we are witnessing currently appears, in my opinion, to be an orchestrated scheme of some sort to bias this court and or to intimidate this court. Here I'm making special reference, and I saw this on the television media and also on a headline of the New Vision of the day before yesterday, when the Honorable Sentamu Kyagulanyi, who is the applicant currently, made reference to his displeasure at the participation of 3 judges of this Supreme Court. Now, my Lord, of course, it behoves all lawyers of this court to desist, either them themselves, and indeed, if not them, to impress it upon their clients, that a trial, any trial, but of course especially a presidential petition, is very serious business. This Supreme Court is the highest court of our land, and it operates in an open and transparent judicial environment. The necessary respect must be accorded to the court, and all counsel, indeed everybody, are duty-bound to adhere to this. Specifically, he called a press conference at which he requested, actually he vilified 3 judges of this bench and asked them to recuse themselves on the basis, and I quote, that they do not have confidence that they will get justice while at least these 3 judges or justices are on the quorum. This, I'm just quoting him. Now, my lords, of course a litigant is perfectly within his rights to seek a recusal. Only that the venue for doing that is here, before this court, and such application, of course, must be grounded in substance, etc., etc. As head of the bar, my lords, I was sincerely hoping that we would attend to the matter of this trial without the theatrics that we are currently being exposed to and that are being played out currently, because of the obvious importance of this matter. The applicants, on the other hand, seem keen on pleading to a different gallery. This court went to great lengths last week to interrogate this matter, great lengths. And I can quote, the court did say in the last proceedings that to all the parties, including the media, that there are rules about court cases which are age-old and are there for a purpose. The court went ahead to say, the petitioner has chosen to come to court. He has not chosen to go and present his case in a marketplace. Therefore, leave the court to do their work. That's in quotations. So, my lords, you must forgive me for telling you how disheartened I am at how this whole matter is being played out in the media, more or less seeming to amount to some intimidation of sorts. This cannot and must not continue. I have the highest respect for Honorable Segona, whom I'm not shy to say is a friend of mine. He was in this court, and I think he's well aware of the rules, and if his client isn't, he should make him so aware. The only description I could come out with myself, as I was reading and watching the press and the interviews, was this an attempt at a trial almost by blackmail. As I've already said, a recusal application is allowed in the law, but the venue is very well known. Therefore, and my lords, when you go to Article 128 of our Constitution, that talks about the independence of the judiciary. 128.2, if you might allow me to read it, it says that the article is 128 talking about the independence of the judiciary. 128.1 says, in the exercise of judicial power, the courts shall be independent and shall not be subject to the control or direction of any person or authority. Number 2, 128.2 says, no person or authority shall interfere with the courts or the judicial officers in the exercise of their judicial functions. I dare submit that what I saw the other day was an attempt at interference. Not to belabor the point, my lords, I humbly request that this court takes appropriate remedial actions to bring us all back into line. I thank you, my lords.
Counsel for petition, you have something to say?
Yes, my lord, to the extent that my name has been mentioned. First,
He has also named your client.
true, my lord. As you will appreciate, my lord, instructions are specific. And let me be on record stating that with respect to recusal, which I have had the learned Attorney General talk about, I have no instructions of any kind, whether specific, general, or otherwise. I want to reaffirm my knowledge and support of for Article 128 as has been read out by the Attorney General. It is the cornerstone of our practice as lawyers to accord the necessary respect to courts. Otherwise, there will be chaos. 3, my lords, and I wish to complain now that my learned friend, the Attorney General, who is the head of the bar, has not, until this morning when I went out of my way to greet him, raised this issue, which would give me ample opportunity to interrogate the same and probably seek instructions, if any. I agree that a matter in court should be in the exclusive hands and four corners of court and nowhere else. And that has been my practice for the last 18 years. The Attorney General has equally not availed me with an opportunity to look at the material that he was able to look at. But my undertaking from the bar, my lords, is as follows. 1, immediately after these proceedings, to have an engagement with the applicant and know the circumstances and context with the applicant, my lord. That's my client. To know the circumstances and context in which he said those words, if he did. My second undertaking is to undertake a duty.
Counsel Bega,
Yes, my lord.
you are the lead counsel for the petitioner. Have you had, is this the first time you're hearing about what the learned Attorney General is speaking about?
No, my first
You
was...
didn't know about it until when he raised it?
until I saw an affidavit yesterday sworn by the Honorable Stephen Tashobia that he was talking about words similar
So
to
you,
those.
in other words, you were the only person in Jerusalem who didn't know about these things.
No, my Lord, I don't know much about Jerusalem. I would be pleased to. But the point I'm making, I received this affidavit of Honorable Stephen Tashobia yesterday evening as I was leaving office.
Okay.
I went with it and read through the affidavit, and unfortunately, it did not trigger my action of calling the applicant.
Fine.
To talk to
Proceed,
him.
proceed, please.
That said, my Lord,
I was just seeking clarification. But proceed,
I'm
yeah.
most obliged, my
Yeah.
Lord. That said, my Lord, like I did say, I would definitely take up this matter, with or without instruction of this Honorable Court, now that it has been raised by somebody senior, and I take it as a serious matter. The prayer, my Lord, raised by the Attorney General, I am not averse to further guidance and direction of this Honorable Court. With or without them, I have and undertake a duty of a professional advocate. I thank your Lordship.
Okay. Any other person wishes to say a word? Learned Attorney General, Learned Counsel Lubega, thank you so much for this presentation coming by way of preliminary statement. Let me state this on my behalf and that of the court. My sisters and brothers sitting over this case. As you said, the Learned Attorney General, I was quite clear, or at least I thought I was. The last time we sat here, I spoke in no uncertain terms on how we will conduct the modus operandi, how we will conduct ourselves. The matter you've brought before us today, you fear it is a scheme to bias this court or to intimidate or blackmail this court by the vilification of a number of justices of this court, including the Chief Justice. I just want to say this. The lordships, as is provided for in the Constitution, took an oath to protect the Constitution. In the oath, we all took oath, and I'll read it out verbatim. Each one of us said, I will well and truly exercise the judicial functions entrusted to me, and will do right to all manner of people in accordance with the Constitution of the Republic of Uganda as by law established, and in accordance with the laws and usage of the Republic of Uganda, without fear, favor, affection, or ill will. Guided by these principles, contained in the oath we took when we become judges, one, a matter which circulates outside of court, we do not attach any importance to it. As you rightly said, if anybody has a grievance, if anybody has any issue to raise with any of the judges here, this is the forum. They come before us, present their case, and we attend to it without fear, without favor, without affection or ill will. Let me also say this. Fortunately, I know the Chief Justice of Uganda very well. I think I've known him since childhood. If anyone thinks he can intimidate, he can blackmail, he can induce with favors that Chief Justice of Uganda, then he's heading for a crash against a huge rock. Because one of the things the Lord God denied him is fear. Once he has conviction that what he's doing is right, and if it is a judicial function, he's doing it in accordance with his understanding of the law as he has applied to the evidence, you may have to make a discovery that the person you think you know, you do not. So, speaking for the Chief Justice, whom I know very well, Counsel, rest assured that whatever is circulating outside there will have no bearing in how this court will determine the matter before us. As a matter of fact, this application came after the alleged utterances. Then that is evidence that what was being said there was idle talk. It was meant for whatever reason, but I consider it idle talk. Because if somebody truly has no confidence in me, he will not come before me seeking remedies. The first thing he would have done was to come to me and say, I want to proceed with my case, but I want you out. I want Judge A out, Judge B also out. This has not happened, meaning that was just idle talk, whatever the purpose was, assuming it was done. So I give you the assurance, we will proceed with this application, we'll proceed with the petition, and nobody should have the fear that we will favor any person or we bear ill will against any person. We'll act according to the dictates of our oath. And for me, the only thing I fear is my conscience. If I go home and I don't sleep after hearing a case, then something is wrong. I wake up and rethink. But when I make a decision and I go and sleep until morning, then I know I am at peace with my conscience. That's what matters. Not what you think of me, but what my belief is. We are not opposed to fair criticism. I said this before. And the positions we hold, we expect criticism. But criticize my conduct, criticize my decision, tear it to pieces, but why attack my person? When you know I do not have the opportunity to stand up there and respond to you. First of all, it is cowardly. Because you know I do not have the opportunity to stand up there and respond to you. Indeed, if the learned Attorney General had not raised it, we would have kept quiet. But I thank you that you did. It's given me the opportunity to let everybody, all and sundry, know that you can choose to vilify us 1,000 times. But when you come before us, that one will ignore. If you have a good case, I will decide in your favor. That notwithstanding. Because that is the oath I took. That is the oath all judicial officers took. That whatever you do to me, when you come before me and you have a case, I will operate from a much higher moral ground than you. And that's how we intend to proceed today, tomorrow, until the task before us is done with. And since you raised it, we all saw this. I mean, we'll be pretending to say we have not read this. If indeed the petitioner chooses to take another path, we have no powers as court to stop. We never invited anybody to come to court. If you have a plan B, you don't even need our permission. You pursue your plan B, for us we'll be done with whatever is before us. But as I said, we'll show the difference between judicial function and political function. It will not get into our head. As I said, the Chief Justice, whom I know very well, will not be moved by those things. He will decide, together with his sisters and brothers on this panel, the matters before us in accordance with our judicial oath and conscience. I suppose we can proceed now.
My lords, may I therefore take this same opportunity to thank you for the guidance and for the reassurance that in any case I have been aware of for the last 18 years. Secondly, my lords, receive the assurance of the bar, at least on this side, that anything we feel we need, we will place it before you and nowhere else. Turning to the application before your lordships. My lords, for the record again, my name is Medad Lubega Segona. For the applicant, with the assistance of all counsel mentioned earlier. The application, my lords, is brought under sections 98 and 100 of the Civil Procedure Act.
For how long do you intend to address court?
My lord, I would intend to address you for an hour, but I would be guided by your direction.
Councillor Lubega, you would like to address us for 1 hour on this application?
That's correct, my lord, to the extent that I'm permitted.
That is interesting. I thought you were going to ask me for 10 minutes and finish in 6.
My lord, I must...
Well, I give you half hour, 30 minutes to submit, and don't make me exercise the other power which I have to ask you to sit down. 30 minutes, you'll be done.
I thank you, my lord.
And the responses will also be 30 minutes for each party. You will have 10 minutes then for any rejoinder, if there is one. And you know the rules about rejoinder.
I'm properly guided, my lord.
Yes, so use your 30 minutes.
And
I'm beginning to time you
I
right
will
now.
as well endeavor to use less, because there is an indication from court that you want me to use less, and I will do that, my lord.
No, you have the 30 minutes is yours. Don't be intimidated by court. Just use, don't get stampeded.
Thank you.
Use the 30 minutes.
Thank you, my lord, for the assurance. I feel now safer and comfortable.
You
in
are
stating
always
that
safe,
the
Mr.
application-
Lubega. You know you're always safe, very safe.
Thank you, my lord.
Yes.
My lord, this application is brought under sections 98 and 100 of the Civil Procedure Act, Cap 71, rules 15 and 17 of the presidential elections, election petition rules, and rule 2, sub-rule 2, as well as rule 5 of the Judicature Supreme Court rules. It seeks for the orders mentioned, and I'll be brief to say that the filing of pleadings is ongoing. That's the grounds. That the filing of additional affidavits in the petition is necessary to enable this honorable court effectively inquire into and determine the questions involved in the petition. 4, that there are prevailing special circumstances to warrant the grant of the application, and that the application is brought without delay. 6, that the respondent shall not be prejudiced by extra time being granted to the petitioner to file additional evidence in the petition. And finally, that it is in the interest of justice. It is supported by 2 affidavits, my lord, of the applicant, the Honorable Sentamu Robert Kyagulanyi, which is accompanying the application, and that of Mr. Anthony Mbale, who is one of the lawyers involved in the petition and therefore conversant with the matters before your lordships. I am required by lords, by precedents of this honorable court and other courts, to prove special circumstances that justify the grant of your exercise of discretion. The special circumstances, with your permission, are contained in the applicant's affidavit, in particular, paragraphs 18 to 22 to paragraph 24 of the petition. It is true, my lord, that this court gave directions when we last appeared, which the petitioner stroke applicant was not able to comply with, and not out of his own motion, but because of the circumstances that he has alluded to in those paragraphs I've referred to. 1, that a number of his witnesses were not released on bail as anticipated by the General Court Martial and other places where they were being held in detention. 2, that the part of the evidence which was locked up in the offices of the National Unity Platform could not be accessed, and that the military siege over the offices was only lifted on Sunday, the same day, evening, the same day he was supposed to have concluded with the filing of the affidavit, and could only be accessed on 15th. But nonetheless, he worked around the clock to get evidence from alternative sources, but could not do and conclude in time. 3, my lords, that that's under paragraph 21 of his affidavit, that was only able to access some of the witnesses in prison on Sunday, having been cleared on Saturday night to be able to get evidence from these witnesses who are incarcerated in prison. That a number of would-be witnesses were thrown into distant places from Kampala without money and transport, which imposed an onerous obligation onto the petitioner and his team to go and collect them so as to be able to access the evidence. And my lords, these are thrown by abductors who are state actors. My lord, those circumstances notwithstanding, by close of business, as indicated and directed by this honorable court on 14th, that is the Sunday we were supposed to have filed, he had been able to collect the evidence, the affidavits, but could not submit all of them on the clock. He continued, according to the affidavit of Anthony Mbale and the applicant, to come in with affidavits until he found the gates closed. My lords, that those are special circumstances calling for your intervention. The evidence that the applicant seeks to bring, my lords, will help this Honorable Court in effectively and conclusively determining this matter. In the summary of what that evidence seeks to produce or to bring before court is contained in paragraph 32 of the applicant's affidavit, which, with your permission, I would like to read verbatim. That the additional evidence I obtained from about 200 witnesses across the country is necessary to enable this Honorable Court effectively inquire into and determine the questions involved in the petition, in that, A, it brings to the fore the various abductions, imprisonments, torture, murder episodes of the petitioner's supporters by agents of the first respondent and the third respondent. B, it reveals how results declared by the second respondent were falsified in favor of the first respondent. C, it brings to fore the various cases of bribery committed by the first respondent and his agents. D, it brings to fore the circumstances under which the independence of the second respondent was compromised by the authority of the first respondent abusing the power of incumbency. E, it portrays the audio-visual expression of how the agents of the third respondent selectively enforced the electoral guidelines and used excessive force to frustrate the petitioner's election campaigns in favor of the first respondent. F, it brings to the fore instances of voting in the names of deceased persons and persons out of the country. G, it brings to the fore how the second respondent relied on incomplete, improper, and incoherent voters' register in the election. H, it brings to the fore how the second respondent unlawfully, inefficiently, and covertly deployed biometric voter verification kit, BVVK, and electronic results transmission and dissemination technology systems, ERDTS, without access by the petitioner, denying him the right to verify voters and audit the results. Finally, I, it brings to fore how the petitioner's stronghold district cities of Kampala, Wakiso, Mukono, Mpigi, Gulu, Masaka are not the first respondent stronghold districts of Kiruhura, Isingiro, Bunyangabo, Kazo, Kamwenge, Chankwanzi, where the epicenter of intimidation and violence against voters and how they affected the percentage of voter turnout in favor of the first respondent as against the petitioner. My Lord, this evidence is important. My Lords, timelines are important in this petition and therefore as necessitated by the application. It was envisaged that there would be situations where an applicant would be curtailed and not therefore unable to comply with the directions. But all effort has been made, my Lord, getting all the 200 affidavits, commissioning them, binding them, and producing them within the time limit was an onerous hurdle. Luckily, those affidavits are ready. They only await your permission. The respondents, my lords, have filed affidavits in reply. The unique one, though, and this is where I would make my very best attempt in approaching the affidavits in reply. The most unique is the affidavit of the registrar of this honorable court. Unique in a sense that in my practice, I have not come across and therefore been confronted with an affidavit from court. In the event that I do not do a thorough job in this, please pardon me because it has an effect on my adrenaline. That said, I continue to be fortified and assured when your lordship, the Honorable Chief Justice, said I should not feel intimidated. Let me look at the affidavit of the first respondent. Can I have it? The first respondent has filed an affidavit through Mr. Isingoma Isao, filed in this Honorable Court yesterday, 18th February 2021. In effect, it only talks about failure to file the affidavit.
Wewa buterevo oli ku BBS Telefina yaffe ey'obwakabaka bwa Buganda ebigenda maaso mu kooti byebyo era buterevo tukyagenda maaso ku mikutu gyaffe ya social media osobola okutugoberera ku Facebook osobola buterevo kuba nti okyagoberera ensonga eno naye tugera kuwumula mbwe tudda tukyalinayo akalaaca tova ku Telefina yaffe nze Morris Mukiibi omugave.
Baby Junior Jelly mukwano gwafe alino mukwano ogwa mama muwewevu era yakuma ensusu zawe buli kadde.
Of the Honorable Stephen Tashobia, Commissioner, on behalf of the second respondent in this matter. A number of his averments with respect to the court record are correct. He only brings in matters that, like I said earlier, are alien to me and are not known to me, and I have not been gifted with evidence of the alleged statement by the applicant. The circumstances could not permit a rejoinder because, like I said, I received this on my way out of office yesterday evening, and it was not my intention to continue delaying the process of hearing this application. That said, my Lord, Honorable Stephen Tashobia does not attach evidence with respect to the conduct of the applicant, which gives him the basis of stating, as he does, that this application is brought in bad faith. I invite your lordships to consider and only be pleased to consider matters that are placed before your lordships. Anyone with extraneous evidence should bring it other than engaging this honorable court in a series of rumors. I submit that without evidence, what is alleged as against my client, the applicant, to constitute the grounds upon which Honorable Stephen Tashobia believes in paragraph 21 of his affidavit, that this application is one brought in bad faith and an attempt to mobilize the public against this court, should be discarded, disregarded, and rejected. Why, my lords? Because they lack evidence. Two, that the applicant has not been heard on this particular fact. That said, my lords, my instructions are to come here and nowhere else. Another affidavit, my lords, has been filed in support of the third respondent's case. Again, in some material respects, it reproduces the record of court. And to the extent that the record of court is accurate, as I agree it is accurate, my lord, those affidavits are correct. However, paragraph 15 of Mr. Alan Mukama's affidavit is talking about that the Supreme Court informed the registry team to close the gates in accordance with the court order. We are not aware of a court order directing that at 5 the gates would close and that people coming in with documents would be locked out. However, yes, we concede that the closure time was 5 o'clock. It is for the same reason that having hit that deadlock, we are appearing before your lordships. We also think, my lord, and this I owe as an officer.
Mr. Lubega, you began with the affidavit of the registrar of this court.
Yes, my lord.
Now, I want you to address us on what Council Wameli says transpired on Sunday the 14th and what the registrar says. Where they are at variance, I really want you to address me on that.
Wait, my lord, I'm fortified. I'm grateful that you have permitted me to address you on that.
Yes.
Like I said earlier, first of all, it gives me enormous difficulty addressing an affidavit of court.
No, that's not the affidavit of court. That's the affidavit of an official of the court, sworn. And if I saw an affidavit, you could even insist you want to cross-examine me, in which case I would have to stand and be cross-examined.
How I pray it doesn't happen, my lord, in my remaining time of practice.
Then I shouldn't swear, or I shouldn't be a witness.
I would have advised that way if I had known that the registrar was about to swear one. That notwithstanding, my lord, and that said, I am not, as an advocate, in a position to cast any doubt on an affidavit sworn by the registrar of court. I disclaim that ability, my lord. I come to court with a tone.
No, let's sort that one out. I know the difficulty you think you have. There should be no difficulty. Council Wameli, if I remember, I read his affidavit the other day. He says he came with volume 2 and the other volumes on Sunday the 14th. And as they were registering volume 2, time caught them, I'm paraphrasing. So he could not register that volume now, and he came back the following day.
Yes,
but the registrar says he came with volume 2, but only 7 copies. And she then sought my direction, and I can tell you I was here both Saturdays and Sundays, leaving at 7 p.m. or thereafter, both days. What to do, because there were only 7 copies, 3 of which were given to representatives of the council, the respondents. And then she says I gave her directives to extend the time up to 6 p.m. for purposes of receiving the additional copies of volume 2. That is her affidavit.
True, my lord.
And they did not beat it. She sought my directive again, and she says I directed her, let them file first thing in the morning, which they did, and that's when they came up with the other volumes. Your learned friend says something different.
My lord?
Yes.
I thank you.
So either the registrar is lying, or your learned friend is lying.
My lord, my eyes have not gone that far to make a conclusion that one of them is lying. My reading of the 2 affidavits, however, drive me to one conclusion, that the affidavits were not presented to the registrar. I think the beginning point, with your permission, would have been to be guided by Rule 13 of the rules of this Honorable Court. Because what Rule 13 provides, if you permit, I'll read, acceptance of documents lodged out of time. The registrar of the court, and they say here the Court of Appeal, as the case may be, shall not refuse to accept any document on the ground that it is lodged out of time, but shall mark the document with the words, lodged out of time, and inform the person lodging it accordingly. When the document is accepted out of time by the registrar of the court, he or she shall inform the registrar. I suppose they're talking about the registry staff informing the registrar. Mm-hmm. And what that would do, my lord, is it would impose an obligation onto us to formally apply to this Honorable Court to validate if you find pleasure in the application. What Mr. Wameli says is that I came with them. The registrar says, no, I did not receive them, and it is true.
No, the registrar doesn't say I did not receive them. The registrar says he came with volume 2 only, but even those were not in sufficient numbers.
My lord,
the registrar says the first time he came with the other volumes, I think they go up to, I can't remember, was Monday, 15th.
True, my lord.
That's what the registrar says.
And that's what
your learned friend, Mr. Wameli, says he came with all of them. That day, the registrar, time caught him as they were registering, and the registrar declined to something like that.
I think, my Lord, my submission is this, that one, they were not submitted to court.
No, were they brought to court on Sunday? Because they came from your law firm.
We did
Were
dispatch.
they brought, did you have them ready on Sunday? They were brought to court. For some reason, the
Not
registrar
by
did
5,
not.
my Lord.
Hmm?
Not by 5, and that one is considered.
By what time?
Beyond 5, yes, because we started sending volumes before 5 o'clock, and we continued sending until the time when they said, no, the gates have been closed.
When was that?
That is Sunday evening, my Lord.
No, what time was that?
By the time they closed?
The registrar is very clear
Yes.
that the Chief Justice directed her that if they have already brought copies of, which was volume 2,
Yes.
then extend by 1 hour for them to bring the other copies of volume 2.
True, my Lord.
They failed to do that. They sought the direction of the Chief Justice again, who said, fine, if they are not able to bring the remaining copies of volume 2, they can then bring it Monday morning.
And my Lord, I find not difficult.
Nothing to do with other volumes.
And my Lord, I find not
Actually,
difficult.
no suggestion that there were other volumes, either in court or still remaining
I
outside.
find no difficulty, my Lord, in conceding that the position of the registrar is the correct position. They were not produced.
I think so. Yes.
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 And my Lord, I am trained to concede
Yeah.
and appeal.
Okay.
To
Now,
your-
fine. You submit on the
to your
merit for the
conscience.
application. Yeah.
So, my Lord, with that, we pray that you be pleased, as you've been pleased in other cases, to extend time. Permit me, your lordships, to refer to the authority we have touched. In our bundle of authorities, it is page 42, and that is authority number 6, and that is Joseph Initiative Limited versus Akugizibwe Jocelyn by the Honorable Justice Gadenya Paul Walimbwa, which I invite your lordships to be pleased to consider. At page 48, my lords, to page 49.
What was the nature of the matter before court then?
It was an application, my lord, for extension of time. And that is what we are here for.
In what? In civil matter?
Yes, my lord. No. My lord, it was a judicial review matter in a civil matter. It is miscellaneous application number 51 of 2018.
Yeah.
And he reads, my lord, he writes at page 48, it is clear from order 51, rule 6 of the civil procedure rules, that the court can extend the time for doing certain acts under the rules. The rules do not, however, provide a blanket check for extension of time. The party seeking for the extension of time has to show that it was prevented by sufficient cause from taking particular step in time, and refers to authorities, where it was held that 3 questions to be determined before disposing of an application for extension of time. 1, where the applicant has established sufficient reasons for the court to extend the time in which to lodge an appeal, whether the applicant is guilty of dilatory conduct, and 3, whether the injustice will be caused if the application is not granted. My lord, he was making reference to the decision of Moli Chalikunda Tulinawe and 4 others versus Engineer Ephraim Tulinawe, and another, a decision of the Honorable Justice Chisache Chitimbo in this Honorable Court. And the same authority is attached in form of authority number 2, which is pages 10 to 23. It is the decision, my lords, I have been referring to, but in particular, it's page 18 of that decision, where the Honorable Lady Justice writes, it is therefore important to consider the following 3 questions before I can dispose of this application. 1, whether the applicants have established sufficient reasons for the court to extend the time in which they may lodge their appeal. 2, whether the applicants are guilty of dilatory conduct, and whether any injustice would be occasioned if the application is not granted. The injustice that would be occasioned to the applicant, my lord, is that in a presidential election petition, a matter of that grave importance, evidence would be left out, evidence that has the capacity to set aside an election, and which emphasizes the democratic path of any country. My lords, authority number one in our band of authorities is Uganda versus Ntambi Vincent. And at page 6, 7, and 8, the same principles are mentioned, that the time should be extended for sufficient reason, which is given for in relation to the failure to take a required step. Time will not be extended if the applicant is guilty of dilatory conduct or inordinate delay. I submit there was no inordinate delay in this case. If you look at the affidavit of the applicant and Mr. Mbale, my lords, Mr. Mbale wrote Monday morning with the guidance of court and seeking permission of court. And the answer was only received in the evening of that day. That is Monday.
Mr. Lubega.
Yes, my lord.
Maybe I'm lost. The court had a timeline here. We all agreed to it here. What permission was being sought from the registrar to extend the timeline?
Well, my lord, to receive. And
To-
that
to-
would
to
give
what
us an
purpose?
opportunity.
To what purpose?
The same documents we are talking about, my lord, which had been brought,
To receive and give you an opportunity to?
we would file to expedite the process. We would file an
Why
application.
didn't you then file an application 8 o'clock in the morning of Monday the 15th, knowing that you were out of time, the timeline we had indicated here? Why didn't you begin with an application? Or why didn't you file an application on Friday 12th? Say, look, we now know we will not be able to beat the deadline. I would have constituted this court on Saturday to hear that application.
Thank you, my lord.
Yes.
To-
So did you need to ask the registrar for that when you knew very well that this is the timeline?
First of all, my lord,
Yes.
I thank you. It was improbable to think that we would fail, because it is evidence that keeps trickling in. Secondly, my lord, and why we could not file on Friday, at that time we are still preoccupied with beating the deadline.
What do you mean evidence that kept trickling in?
My lord, evidence comes from across the country.
Yeah, but you told me your witnesses were in jail, so how could evidence?
No, there were
fail
quite a
in?
number, and we continued securing release of a number of them. Those that were abducted were being thrown on the streets. We would pick them, and we get evidence. You will find it if you permit. Those that we were in jail, we were continuing to pursue their bail applications. Again, as the evidence on record indicates, we had a bail application where which was only fixed for Monday, a day after the deadline, and we were continuing with all efforts, my lord. But why we did not file again on Monday, on Sunday before? Yes, we were preoccupied with gathering evidence in the hope that we would be able to beat the deadline. We were not in a position. But we also thought we had Rule 13 in mind, that the affidavits would be received with this indication, whereupon we would quickly file an application for validation, and we had it in mind. And we do not want to blame court, my lord, for not receiving. We're only saying we had this, not misapprehension, but this thinking that they would be received. Now that they were not received, my lord, the option that was left for us was to file an application. Yep. And by Monday, we were still hoping to have them received. Tuesday was a public holiday. Wednesday, we filed.
But Mr. Lubega, you are saying if it was not received, you would not be able to file an application?
No.
Was filing an application contingent on the registrar first receiving and endorsing that this was brought out of time,
Yes, my lord.
or you could file an application anytime.
Yes, my lord, because these are two different applications. If they are received, the application would be a different one for validation. But if they are not received, the application would be the current application, my lord.
Yes.
So it definitely had to be dependent.
Okay,
on whether they are received.
then you have a copy of this application of yours?
I do, my lord.
Yes. Can we go to the first page? There is a stamp of the Supreme Court on mine. I suppose it is on yours.
On the application, my lord?
Yes. On the motion, on the notice of motion, there is somewhere up there. I don't know where yours is indicated.
Of which date?
No, do you have a copy of your?
Yes, my lord, I have a stamp of 17th.
Yes.
Yes, my lord.
Does it indicate time?
No, my lord.
Oh, it doesn't?
It doesn't, my lord.
Can you borrow mine?
My lord, I would receive any information from you without taking.
No. I want you to look at it. Don't mind, I don't have corona, but
No, my lord, I don't want to infect you either.
I test myself every 2 days.
My lord, I equally do not want to be accused.
So kind of you.
My lord, the court supplied me with a defective bottle of sanitizer.
Or
I would
maybe,
appreciate if someone
maybe you don't know how to operate it.
or I'm not strong enough to press.
No, you loosen a little bit first.
Oh, thank you, my lord. My lord, it has an indication that it was filed at 17 hours. Presumably that's
In the 12-hour clock, what time would that be?
it would be 5 o'clock. 5 o'clock.
Yes.
May I have it returned?
Thank you. My question is this really. Yes, on Monday, you filed, you tried to file affidavits which you knew were out of time, which happens. It does happen. Yeah. I'm not saying this is the first time such a thing happens. No, it happens. And if you persuade me, of course, I'll give you additional time. If you don't, I will not.
My
So
lord,
my
I'm
question
here to do
is,
the latter.
yes, you're here to persuade me, yes. So Monday, you knew you did not. Under the mistaken belief that you should first of all hear from the registrar and then make a decision on what to do. You discovered that the registrar will not receive it. Tuesday 16, you did not come here. I can tell you that this place was open. But you did not come because it was public holiday. Can you explain why you did not file the application first thing in the morning of the 16th? Why would you come and file the application 5 o'clock? You filed the other affidavits 5 o'clock, including the ones you told this court, and it is on record, that you had 50 affidavits you were even prepared to file that day. You filed at 5 o'clock on the last day. Can you explain? I mean, what is it really? Is it some game plan or what? I mean, why wouldn't you, if you had filed those affidavits, which would have served on the other side, they would have started the work of responding. Then you would not have been filing the 50 affidavits on Sunday. You would have come to me and say, my lord, I gave my word that the following day or soon thereafter, I would file another 50 affidavits. It's become a lot more difficult. And these things happen. Don't think we don't know. We know they're difficult. Anything can happen. So why must you always come at 5 o'clock?
My lord,
What is the magic wand about 5 o'clock?
First, my lord, there is no magic about 5 o'clock to begin with. Two, my lord, yes, any delays are regrettable on our part, and we do not want to justify them. To the extent that the question is being asked to council, you will permit me to answer from the perspective of council.
No, I'm
And
asking,
therefore-
because it is your law firm. I cannot ask the petitioner. This is directed to you. He has entrusted you with the responsibility to represent him professionally. And I notice a pattern, which I've just mentioned. Even when you gave your word, you did not honor.
My lord,
Yes.
to the extent that I must, as counsel, to answer this question, the answer will not be found in the affidavit, but it will come from me.
You are an officer of this court.
I
I would take your statement seriously.
I attempt to practice law professionally, that I avoid alarming statements. It is now my time to tell you that for the last 3 weeks, I have not been working from my office. I have not been sleeping in my house, to avoid situations of 2016, where affidavits which were supposed to be filed in this court were stolen by armed men from lawyers' offices. And it is very painful that I have to reveal this now. We work from different stations. We keep running up and down to avoid situations of 2016. Witnesses have been abducted. The lawyer is not safe. I regret that the application was filed at 5 o'clock.
Mr. Lubega,
Yes, my lord.
you know, I understand all those things. I appreciate your fears. And in your circumstance, I would also take precautions. What I do not understand is your own statement here in this court on the 11th, on the date we had set for scheduling and kick into motion the process. You said you had 50 affidavits ready, which you could file that day. Meaning you had already finished running around, hiding all over the place. You had now assembled them, you are going to file them. That is my understanding. So why didn't you file it, and you had to file at 5 o'clock on the last day? That's one. Two, you said another 50 would come, if I recall, is it the following day or something like that? Yeah, that's the part which I thought you said, okay, I had thought I would have them, but for this or that reason, it was not possible. By the time you told me you were prepared to file 50 affidavits, even that day, operating from wherever and having to run all over the place, you had successfully done it. I did not see any affidavits. That's why I'm saying, what is the game plan? I don't understand. Because all these arguments you're making, if we had had affidavits trickling in from the date you filed the petition, taking care of the difficulties the petitioner had, which we know on record. We also know that he had to apply to court to give him freedom. We know this is a court document, which we take judicial notice of, the order of court. You don't even have to submit because we have it. If the affidavits, even if they were one a day, or two or three, we can understand. What I don't understand is, you have the affidavits, you assure this court, as an officer of the court, I have these 50 affidavits. Even today, I hope I'm not mispresenting what you said. Then those affidavits do not come. They're the ones that come. Do you want me to tell you? Your team came on a border at 4:35 outside here, because I was here. I wanted to make sure that there are no hitches. Because to me, a presidential election petition is a very important thing. I don't have to restate. And as I told you the other time, it's not about the petition. It's about your country. It's about my country. I have children, you have children. I beat you one notch because I have grandchildren. I don't want them to see what I saw from independence. If I can make a contribution, that my grandchildren live in a country where they think it is some fairy tale when we say this used to happen, I would be very happy. So I was here. And that's why the registrar was seeking my direction at every point. Because this is important. 4:35, they were outside. They didn't come in a vehicle, in two borders. I don't know whether they were personal motorcycles. Ask them, they will confirm.
My lord, it is
Yes,
true.
so I don't understand. You know what? I don't know what the game plan is. I really fail to understand.
Permit me, my lord, therefore, to respond to that, because it is critical and important. First, to appreciate you for that resilience, but also to note, my lord, that lawyers are flying on borders from all directions to bring these documents would demonstrate the effort on behalf of the applicant and his lawyers to be able to file the documents as required. Number two, my lords, all the questions that you have raised are very important questions for the determination of this, and I need to justify or explain why. I am not represented as having said that we would be be able to file those affidavits on that day. I am not misrepresented. We left the court at 1 o'clock. And we had a duty to collect all the affidavits from wherever they were being worked on and bind them and make them ready. But it also occurred to us that we needed to be neater, not to keep throwing one affidavit after the other. You may witness that there are some affidavits which were filed on that day, like the affidavit of Joseph Kableta from different lawyers who were making them. But we thought the record of this court would be more organized if we filed in bundles. And that, my lord, is my reason, although admitting, yes, that we should have done what you're guiding we would have done.
Okay, very well. Continue.
Thank you, my lord.
Yeah.
We, in the case of, I was addressing you.
I'm giving you 5 minutes.
I am happy to take them, my lord.
Yeah, that takes you up to...
Authority number one.
Up to the 1 hour you had pleaded for.
Oh, sure.
Oh, yes.
I'm grateful, my lord.
No, 45 minutes. Takes you
Thank
to
you, my lord.
45 minutes.
In authority number one at page 6, the principles governing extension of time, court elaborates them, and inordinately is what I have been explaining, my lord. It was just 1 day after, and we did file. Finally, let me submit that this case presents unique circumstances. Just from the date of filing, I hope not to the date of conclusion, we seem to be stabilizing in the hope that this application would be granted. My lord, where you have a litigant in charge of the security of others, detaining his opponent to begin with and denying him 10 days of filing a petition, detaining his opponent's witnesses, and this is the power of incumbency abused that I want to bring in the evidence. It is a unique circumstance. Lawyers operating mobile law firms with a precedent that affidavits intended to be filed in this court have been stolen by players of the state. It is a unique circumstance that I invite this honorable court, notwithstanding our failures, which we admit and regret.
Okay.
My lord, it is a case worth granting the prayers played for. Finally, my lord, I admit that, yes, it places some onerous...
Counsel,
Yes, my lord.
I would like you to address us on Rule 17 of the election petition rules. Can you place your application under that rule?
My lord, with your permission, Rule 17 reads, enlargement or abridgment of time. The court may, of its own motion, or on oral application by any party to the proceedings upon such terms as the justice of the case may require, enlarge or abridge the time appointed by the rules for doing any act if, in the opinion of court, there exist such special circumstances as make it expedient to do so, except that when considering enlargement of time, the court shall take into account the provisions of subsection 3 of section 59. Yes, my lord, 1, it provides for circumstances. My lord, section 59, thank you. With the hindsight of section 59, my lord, about the timelines. And that is the issue I was addressing finally. Because, my lord, I was talking about, we are aware that granting this time has an impact on the time reserved for the rest of the proceedings to be taken. We admit. We only pray that, therefore, once you grant this, we would even be able to concede part of our time for rejoinders in order to catch up.
How much time do you think we would have to give the respondents to respond to, did you say 200 affidavits?
Yes, my lord, I would not have a problem giving them the same time you had granted them previously, starting from the time they are served.
Mm-hmm.
On our part, we would concede part of the rejoinder time to respond.
Let's say I give them up to next Saturday.
Yes, my lord.
If we grant this application,
Yes, my lord.
and you serve them today,
Yes, my lord.
hopefully you change and serve them immediately, and we give them up to next Saturday. What impact will it have on the timeline?
It will impact, one, on the time for rejoinders and the time
Because
of court.
because rejoinder does not have 6 days. Rejoinder is it a couple of days?
I think we had been given 3 days, my lord.
3 days, yeah.
Yes.
Mhm.
We would use 1 day or and a half, and would close our time. Yes, it would impact on the time of court, admitted, and we would invite your lordships.
Oh, I thought you wanted, you've come here so that the court, have you come here so that you continue pleading, and then once you plead it, it can end there, or the important thing is the decision of this court?
True, it is the decision, my lord, and that's what
Already, the court has lost actually 1 week. They would ordinarily have taken slightly more, 3 weeks, to be able to do justice to this case. Internalize, consider, evaluate, consider the law, discuss, and come up with a decision or their decisions. We have only 11 days for us to do that, which is really uphill. Then we sacrifice that so that you're not disturbed, because you must be heard, you must present your case. I saw a complaint against written submissions. I hope it is not coming from council, because we have given you an opportunity of more than 2 weeks to prepare for your submission. You write and highlight. So you take away 6 from 11. My poor arithmetic leaves me with 5. That this honorable court would determine a presidential election petition with the very importance you've clearly stated, and on that one I'm with you 100%. In 5 days. Is that possible? And by the way, the new rules do not say we state unanimous, we agree to overturn, or unanimous, we agree to dismiss. It says we give reasons. Read it again. So in 5 days, you believe we can do justice to this case in 5 days. So these are the things we need to put into consideration, whether to grant your application or not. And that's the area you need to, I think that's what my brother was asking, referring you to section 59.
With gratitude, my lord. Yes. I do not think I'm overstretching your abilities, my lord, in thinking that you are able to deliver justice even in 5 days or less. I know that you can.
Thank you. The last sentence, what are your prayers?
The prayers, my lord, that you find pleasure for the reasons we have given in granting this application and adjusting the schedule of this court that has been given before.
Thank you.
Thank you, my lord.
Yeah. Learned Attorney General. I don't know how you organize
Yeah, we'll
yourselves.
start, my
Yeah.
lord, with the first respondent.
Yes. So you're forfeiting and giving it to them to start.
I'm not forfeiting my presentation.
Uh.
I'm only forfeiting the method of starting.
Somewhere in the Bible, somebody gave away his birthright. And
I'm just lending it to him.
Most obliged, my lord. The Honorable the Chief Justice, Honorable Justices of the Supreme Court.
you have 30 minutes, you're aware.
Most obliged, my lord. Chiriwa Chwanuka for the record, for the first respondent. My lord, we oppose this application. My lord, by the dictates of the Constitution, this application was filed on the 1st of February, and it must be concluded. The petition was filed on the 1st of February and must be concluded by 18th March. The court gave timelines. The date for filing affidavits by the applicant was closing on the 14th. It is now 5 days later. The respondent has until tomorrow to file its replies. My lord, contrary to the belief that is stated in paragraph 17 of the applicant's affidavit, this court has always granted timelines. Even in the case of Mbabazi that is mentioned there, timelines were given, and they were strict and they were followed. But my lord, in this case, the applicants have been given 33 days. 33 days out of the 60 allowed from the time of declaration to present their case. They had 15 days to file the petition. They've had 15 days to file affidavits. They have 3 days to file their answer. They've been given 33 days. That's more than 50% of the time. The respondents, on the other hand, have been given 6-7 days to respond to the first 50 affidavits. And my lord, it's been
What percentage is that?
It's about 52%, my
No,
lord.
no, the one for the respondent.
Oh, my lord, it was in the small notes. 10%, less, no, 10%, my lord. 10% of the time. My lord, it's been an odious task, and we are still struggling with it. Unfortunately for us, we dare not ask you for more time because even this day has been lost. We are here, but we must file because the court made an order. My lord, orders of court are not mere technicalities. Orders of court are to be followed. And my lord, as you guided counsel, my learned friend, counsel for the applicant, when you feel difficulty with following an order of court, you do not sit back and act as if you're operating by your own rules. You go back to the court and talk to the court about your difficulties. My lord, it's 5 days after they were supposed to be before you asking for your indulgence, and they are doing it now. My lord, authority number one on our band of authorities bears out this point, that the failure to follow the orders of court is not a technicality. It tells you 126.2 is not going to help you when the court makes an order. My lord, the politeness of court may be misused and misunderstood. When the court speaks to us, they are orders. They may seem like suggestions, but they are orders, and they must be followed. They fail to follow the order, and it has consequences. And the consequences is how well you prepare your case and how well the other parties can prepare their defense. My lord, we close pleadings. We are at the stage of doing evidence, and we are preparing for the hearing. This court
needs to make an effective inquiry into this petition. And the court can only effectively inquire into this petition when it receives evidence. Not these pleadings that we file. When they receive evidence, that's what the court is going to inquire into. That's what the court is going to look at. But my lord, the justice requires a fair playing field. It must be fair. I've already talked about the 10% we have as opposed to the 52%, but that's the law. It's the law, and I'm sure the Attorney General will tell us that if you want the law to be changed, you go and look for an amendment. We have to fit within the four corners of the law. That's the law. But it must be fair. The court issued directives, and we followed them. Council was here and agreed to follow these directives. But my lord, we have annexures A2 to A6 listing 200 affidavits. 200 affidavits. It's impossible. It's an odious task. It is setting up the respondent to fail. My lord, a fair playing field should be so that no party or the court loses the time that he or she is entitled to, and no extra burden should be imposed on any party as a result of the omissions or inadvertences which were foreseeable or could be avoided. My lord, that's the authority number 2, the Raila Odinga case. My lord, in that case, it was actually more interesting because they wanted to file only 8 affidavits. The court said, no, it's too much. You can't do that. At that stage, the court refused. Now they want to file 200 affidavits. 200 affidavits. My lord, that is unfair, and we pray that the court rejects it. My lord, the time that was set, I cannot overemphasize that these are orders of court. My lord, great prejudice will be caused to the respondent, the first respondent, if this application is allowed. My lord, paragraph 18 of Esau Isingwama's affidavit sets out the prejudice that the first respondent will suffer. The affidavits we so far received are scattered all over the country. One affidavit talks about 10 witnesses in diverse places in a district. One person, and as we'll get to the hearing, one person is talking about everything that happened in the whole district. And therefore, we have to keep running one district. Now you have all these witnesses coming from various places and now have been sent back. And then an application. My lord, it is also prudent always that for a litigant to come to court, they must have evidence. We have gotten to the point where we now practice the other way around. I first file a writ. After filing the writ, I look for the evidence. That is what you're getting. That is what is before your lordships. That I had a petition, but now I'm looking for the evidence. How is that possible? How can you achieve a grievance before you see the evidence? How can you say that my would-be witnesses are in prison? How do you arrive at the conclusion that they would be witnesses before interviewing them? It's preposterous, my lord. It's preposterous, my lord, and this is the kind of conduct that this court must absolutely reject. My lord, so many things have been said about what is happening to my learned friends, and I sincerely feel sorry if it is true. But if they felt it necessary for this court to consider the averments being made by my learned friend, he should have put in an affidavit. This ceased to be a political contest. It's a legal dispute. The politics can be left outside and we do the legal dispute here, and the legal dispute, the evidence is brought by affidavit. Half of the things that are being said by my learned friend for the applicant are not on record. They are averments from the bar. But my lord, let us evaluate the evidence that is before you. Paragraph 8 of Mr. Kyagulanyi's affidavit is simply speculative. Paragraph 2 to 11 are matters depend about issues that happened before the court made the order. Before the court made the order on the 11th. What the court should be looking at is what created your difficulty after I made the order on the 11th. So all that evidence before the 11th is irrelevant. It's relevant to the application before you because the court was alive to all those things when they made the order, and counsel for the applicant knew the existence of those circumstances at that time. This disability that this disability to do things, disability relates to the failure to file the petition. You cannot say, I am disabled, I filed the petition, I did not do it properly, but I filed it anyway. You don't go to disability. Disability deals with your inability to file the pleading within time. They did file within time. So that is not the issue here. So, my lord, the evidence relevant before your lordships would start around paragraph 18, 19, 20, 21. And here he discusses his witnesses who are in prison. For those that are not, the question I ask, why wasn't there evidence filed? Or is it to suggest that all the 200 witnesses listed are in prison? In any event, my lord, they don't set out who is in prison. For the applicant, on his affidavit, he actually attached the release order by court. So clearly, counsel knows how to prove to the court that a witness is in prison. But in any event, my lord, why is the applicant coming today? Why didn't the applicant come to you earlier and explain the difficulty that they are suffering? My lord, you did guide here that as parties we should work with each other. We are hearing of this in an application. Counsel has not reached out to any of us sharing his difficulty. I actually didn't know that he was running around, because every time I saw him, he seemed to be very comfortable.
No, he was putting on a brave face.
Yeah, he was putting on and that must oblige, my lord. That is what I didn't know. So if he could share with counsel, because we are in this together, we would know what to do. But on the last hour, you come and say, I want to file 200 affidavits. But more importantly, my lord, none of those people has been proved to you to be in prison. I dare not submit from the bar. But my lord, as you look at that list, take cognizance of maybe what happens on TV, because I've seen many of those making statements. The Secretary General of the party making statements, he's definitely not in prison. Councils are listed before you, are listed in the list. They are not in prison. So, my lord, it's unfair to come and say, all my witnesses are in prison. My would-be witnesses are in prison. That is not the way we plead. That is not the way this court should receive evidence. But, my lord, as I stated, on the 1st of February, when the petition was filed, the applicant was expected to have evidence. And we'll rely on the case of Venkata Authority number 5, which says you don't file a pleading, then look for the evidence. Find the evidence first. But my lord, the timelines in this case are also very important. On 4th February, the applicant attempted to file an amendment to this petition. Again, in that application, which is attached as Annexure B, in paragraph 10, he states on the 4th of February, he states that him and his party officials have gone and interviewed their witnesses and have discovered, and I will quote, discovered evidence from all over the country. That's on the 4th of February, my lord. Today, by the time they saw that affidavit, my lord, it's Annexure B to our affidavit in reply. It's the application that was filed in that application for amendment. They state on the 4th of February that they had discovered new evidence. My lord, if they indeed had discovered new evidence, as has now been repeated in their paragraph 12, again, the Honorable Kyagulanyi swears that he has now discovered new evidence. So I think every time they meet, they'll discover new evidence. When will this stop? It has to get to a point when it stops. My lords, what we are saying here is that the applicant, as at the 4th of February, had already discovered this evidence. There is no justification as to why on the 14th that evidence was not presented before the court. But more importantly, my lord, on the 9th of February, the court ordered that they should feel free to file, and like my lord has stated, counsel, who is an officer of court, said he will file 50 affidavits. Obviously he did not, because the record is clear, and waited until the last day. Again, on the last day, there's no justification as to why he did not file all of the 20 affidavits. clearly this is the nature of the litigant you have before you. But my lord, I beg that you look at the affidavits that have so far been filed very closely. Some of them are dated as far back as 9th of February. Others are dated 11th of February. So they had them. They had them. They did not file them. That is the nature of the litigant you have before you. So for them to have the affidavits on the 9th, why file them? After all, the respondent has to suffer with the few days that he has to run all over the country and bring them. I will not be surprised, my lord, because he told you on record that he had 50 and another 50. I will not be surprised if the other 50 are still lying somewhere. My lord, that is dilatory conduct. That is dilatory conduct. There is no justification as to why this application was filed that late. My lord has already traversed that point, but the timestamp is very clear. My lord, the second nature of evidence that you have before you is the special circumstances being presented to you are falsehoods. Clear, blatant falsehoods. The first falsehood is that you have shared with my learned friend in respect to the time they arrived and how many affidavits they had. Kyagulanyi's affidavit paragraph 24 and Wameli's affidavit paragraph 2 to 3 are false. Clear, open lies. We are borne out by the evidence of the three witnesses whom the court clearly asked to be here. And they were here. And they all say the same thing. For the first applicant, for the second applicant, for the third applicant, the registrar, the only person who sees the facts differently is Counsel Wameli. He's an officer of court. You can't do that. And he talks about a unique nature of an affidavit shown by the registrar. It is unique because no one goes around, no litigant goes around blaming the court for things they did not do. It's unusual. Who else would swear an affidavit about what transpired in court other than the registrar? There's nothing unique about it. You name the registrar for having done something. The registrar has to come to the court and tell the court what happened. It's unacceptable. It is wrong. My lords, but more importantly, they even forget quickly what they wrote in their own letter. In the letter of Wameli, which is annexure A to his application, annexure C, he actually states that the other affidavits, volume 3, 4, 5, 6, 7, and whatever, came late. In his own letter to the court, he says it came late. What justification can one have to write that letter and then tell a lie to the court? My lord, the issue of the affidavits is clearly set out. The court directives are clearly set out. Counsel swears in paragraph 7, Counsel Wameli swears that the court ordered that service will be effected on Monday. This is preposterous. My lord, the record is very clear. We were here. The court even directed how service will be effected. The court even directed that a desk be put up. The court directed that as you file, you are served. How is it possible that my learned friend could have understood as soon as after filing to mean a day later? It's not. It's a lie. It's a lie. My lord, about the closure, my learned friend says he doesn't know, but I'll refer him to the record paragraph, page 12 and page 15. It is attached to our. The court was very clear, very, very clear, that if you come after 5, we will not receive them. You cannot refer to Rule 17. You cannot refer to Rule 17, my lords, to circumvent a clear court order. The court was alive to the principles set out in Rule 17 and made an order. Rule 13, I beg your pardon. Rule 13, my lord. Rule 13 says that the registrar will receive, fine. But the court has said, don't receive. It's an order of court. You can't refuse to do it. The rules are for the court and the parties. And the court interprets the rules. And the court has told us what to do. So Rule 13 is absolutely inapplicable in these circumstances. But my lords, these affidavits are false. These affidavits are false. And relying on the authority number 3 and authority number 4, we pray that this application does strike out those affidavits. We pray that the court does strike out those affidavits. My lord, there is a new thinking which seems to be cropping up about this severance. I think severance related to technical matters, related to hearsay. You can't sever paragraph 7, 4, 5, 2, 3 of Mr. Wamiri's affidavit and remain with anything. Even if you did, which other part would you believe? He has told you lies in paragraphs 2, 3, 4, 5, 6, 7, then he remains with 8 to 10. Do you want my lords to believe 8 to 10? It's unbelievable. It's incredible. It's not credible. We pray that your lordships find that evidence to lack credibility. Strike out this application on that ground alone. My lords, as I close, I would like to distinguish the authorities that my learned friend has shared. Authority number 1, which is Uganda versus Ntambi. This is definitely not applicable because in this case, the DPP was present in court when the judgment was made and then did not file the application in time. So whereas the principles are correct, prejudice is only considered after sufficient cause. So the state then argued that they will suffer great prejudice if the application for extension of time is not granted. The court said, no. We first deal with sufficient cause. Then after we finish sufficient cause, we then discuss prejudice. In this case, my lord, the only sufficient cause you have is falsehoods, lies. That's the only sufficient cause you have. No explanation has been rendered to this court as to why the applicant has conducted themselves the way they have throughout these proceedings. My lord, authority number 2 relates to mistake of counsel. The application before you is not mistake of counsel. The application before you is mistake of court. They are saying that no, it's the court's fault. I came with all my things, the court refused to receive them. That's what they are arguing. That's what the affidavits are saying. That's what we prepared. Fortunately, counsel has conceded that was not mistake of court, and therefore, but he has not conceded that was mistake of counsel either. So this application is not applicable. This authority is not applicable. My lord, authority number 3.
Mr. Kimano, if since Mr. Lubega said the statement by learned counsel Wameli is not correct, the one of the registrar is correct, yeah, then doesn't it mean the mistake is for counsel for the petitioner, who is the applicant? Logically.
Most obliged, my lord.
Yes.
He fell short of saying we were at fault. He did not say that. He actually said that the version of the court is the correct one. And so on that basis that I say it was a lie. That is before you.
Meaning the fault is now for counsel, not for the petitioner.
No, my lord. He's not saying the fault is for counsel. He's saying that counsel was very vigilant. He was running around. He was everything. The witnesses were in prison.
No, but he has conceded. I mean,
he has conceded
when
the
you concede, means you've changed the position.
Most obliged, my lord.
Did he have to say the fault is mine? Or
yes, my lord.
Yeah.
Yes, my lord. There is no evidence. Even he has not conceded.
If he said, if the contest was whether it was in the morning hours, and he says, no, it was not in the morning hours. Yes, the sun was up. It was not morning hours. It can only be afternoon.
Yes, my lord.
Not so?
Yes, my
Does
lord.
he have to say it was afternoon?
No,
if the sun is up, it cannot be night time. And
well,
he says it was not morning.
I'm most obliged, my lord, but
yes.
It could be tending to evening with a high sun. My lord, what we are saying here, my lord, what we are discussing here, my lord, is a very important matter where the council says something. It is not enough for council to just say the version.
I think Council Lubega was gracious. Said, okay, we accept the position that we did not bring these affidavits on the 14th.
Yes, my lord.
In time, and I thought he was gracious. He conceded that point.
Yes, my lord, but he did not say it was his mistake. He doesn't even explain how he arrived at that mistake.
Because it is logical. I mean, the contest was whether it was court mistake or his. Now, if he concedes that it was not court mistake, it leaves only one.
I'm most obliged, my lord.
Yes. Just logical.
My lord, authority number 6. Again, this one was the failure to take a necessary step. Why did I fail to take a necessary step? That was what was being discussed in this authority. We know that a necessary step they failed to take. But that is not what was being discussed in this case. So these authorities are actually not applicable. But more importantly, my lord,
3 minutes.
most of life, none of those authorities discuss the effect of tendering falsehoods to the court. We pray that the court takes that into consideration, and we pray that your lordships be pleased to dismiss this application and that costs be provided for. We so pray, my lord.
Thank you. Yes, learned Attorney General. Who is the next person?
My lord, the next will be the second respondent.
Okay.
My Lord, the Chief Justice. My Lords, Justices of the Supreme Court.
I don't know you, because we can't hear. Have you put it on?
My Lord, I hope that is better. My Lord, the Chief Justice, my Lords, Justices of the Supreme Court. My names are Joseph Matsiko, and I appear for the second respondent. My Lords, we oppose this application and we pray that it be dismissed. My Lords, for this application to succeed, there ought to be special circumstances.
Councillor Masiko,
Yes,
we are, unlike you, we are not very young, so can we have some 15 minutes health break,
much of
so that blood does not clog on our legs? We need to stretch them every, yes. So we will resume here at 7:15 midday.